So, in this video, we'll discuss the contract of bailment and as it is defined by Halsbury in law of England and as similarly defined by Patton, Professor William Jones and Professor Blackstone. So, as defined, a delivery of personal chattels in trust on a contract, either express or implied, that a trust shall be duly executed and the chattels redelivered in either their original or an altered form as soon as the time of use for or condition on which they were built shall have elapsed or been performed, and in the similar way it was defined by Professor Patton, William Jones, and Blackstone. So, Section 148 of the Indian Contract Act defines bailment. It is the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the direction of the person delivering them. So, two terms we derived from the above definition. One is the bailor and the second one is the bailee. So, the person delivering the goods is called the bailor and the person to whom they are delivered is called the bailee. So the very explanation appended to the above section reads, if a person already in possession of the goods of another contracts to hold them as a bailee, he thereby becomes the bailee and the owner becomes the bailor of such goods, although they may have not been delivered by way of bailment. So, in light of the above definition, we'll discuss certain characteristics of bailment. So, the first characteristic of bailment is it consists in the delivery of the goods to the bailee. Delivery of possession is essential in bailment if there be transfer of ownership. Transaction may be a sale or exchange but is not a bailment. But how the delivery to the belly is made as it is provided under section 149 of the Contract Act, as provided under section 149, the delivery to the belly may be made by doing anything which has the effect of putting the goods in the possession of the intended belly of any person authorized to hold them on his behalf. So, in relation to that, we'll discuss a leading case, and that is Kalyanmal versus Vishaka, , , and that is a case of 2021 Supreme Court. 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 2021 Supreme 1938 decided by the Madras High Court. So, a lady employed a goldsmith to melt old jewelry and prepare new ornaments. Every evening she used to receive incomplete ornaments from the goldsmith and put them in a box which was left in the goldsmith's shop. It was held by the Madras High Court that the goldsmith was not liable for the loss of the ornaments, and the reason is that the goldsmith cannot be said to have been the belly of the goods. An essential ingredient of bailment is that the delivery of the goods to be made to the person who is alleged to be the belly. In the case under consideration, the lady kept the key with her. There was as such no effective delivery of the contents of the box to the goldsmith, either actually or constructively. It necessarily follows that he cannot be regarded as belly thereof. And the second characteristic of bailment is that the delivery of possession is temporary, but it is for some purpose. The bailor reserves a right to claim a delivery of the goods bailed whenever there is a delivery of property on a contract for an equivalent in money or some other valuable commodity, and not for the return of the identical subject matter in its original form. It is a shell, and characteristic number 3 provides the goods are delivered to be returned in specie or disposed of according to the direction of the bailor when the purpose is accomplished. And in connection to that, we'll discuss certain illustrations relating to bailment. So, the first illustration, as where B lent some ornament to A to be used in a marriage, the transaction is one of bailment. In such a case, there is an implied contract that the ornaments will be returned in a reasonable time. And this second illustration, giving of goods to a goldsmith for making an ornament is a nature of the transaction of bailment, because a delivery of goods by a person to another for some purpose upon a contract that they shall be returned when the very purpose is accomplished amounts to bailment as provided under section 148 of the Indian Contract Act 1872. So, all that we discuss regarding bailment its definition, and as per the provisions of section 148 and regarding the very characteristics of bailment and all the provisions and illustrations relating to section 149 and the very important leading case, that is Kalyan Mal versus Vishaka Lakshmi in 1938, the judgment delivered by the Madras High Court. All these could be the best answer to the question, and that is the first question. Question number one: state briefly the law of bailment defining the terms bailor and bailey. So, question number one's answer could be all the definitions and as the provisions provided under section 148, the very characteristics of bailment, the delivery of possession, and as provided under section 149, and those illustrations that we discussed relating to section 149 and that important leading case relating to Kalyan Mal versus Vishaka Lakshmi. The very judgment was delivered by the Madras High Court in 1938. So, this should be the appropriate answer regarding the very question. State briefly the law of bailment defining the terms bailor and bailey.